Hi, I'm Kenton, and this is Kenton Knows. In this video, I'm going to explain what real estate lawyers should do in a real estate transaction to guide and protect you while ensuring you get the best deal possible, whether you are the buyer or seller. If you like this video, please hit the like button, consider subscribing to my channel, and leave me any questions or comments below as well. First, I'll start by acknowledging that some states require attorneys for real estate transactions and some do not. But I personally would advise you to use an attorney for every real estate transaction, even if the state does not require one. I will explain the attorney's role when representing a buyer first and the opposing attorney's role when representing a seller. I will then finish the video with what to look for when selecting an attorney for your next transaction. As a buyer or seller, the process starts immediately after you have a fully signed or executed real estate purchase contract, and you should send a copy of the executed purchase contract to your attorney as soon as possible. Essentially, the attorney can negotiate or modify just about anything in the contract except the price, other than requesting credits. I'll touch on a few of the more important points that the attorney should do in all transactions, but one of the big ones would be to help you get out of a bad deal if you learn something that is a deal breaker during the attorney approval period. In most contracts, the attorney should have around 5 business days to write and send an attorney approval letter. This letter should include any items that may be ambiguous or not in your best interest as the buyer or seller. Here are a few items your attorney may call out in that letter. Prorations. Real estate taxes are normally paid in arrears, which means that you may be closing on a property without knowing what the current year's taxes will be. Your real estate agent should have negotiated a tax proration, but the agent may be unaware that this particular property will be reassessed in the coming year, which can result in a larger than normal tax increase. When this happens, the buyer attorney can call it out and request a larger proration credit to you at closing. Of course, the seller attorney will try to keep this percent as low as possible for their client. Special assessments and association information. If the property you are purchasing is part of a homeowners association, there may be pending or contemplated special assessments the association is considering. The attorney should request and review the association documents, meeting minutes, and financials. The attorney should tell you if there has been any discussion of any capital improvements and see if the association has enough money to cover those anticipated improvements or if it will require a special assessment to be paid by all of the owners. If there has been a recent engineer's property evaluation, you would want to review that as well, which should list the expected life expectancy of all major building components and indicate if there are any current or potential issues that may have not been disclosed to you. If there are any issues, you may want to cancel the transaction or request a credit from the seller for the issue. As a seller, your attorney will argue these are normal items and that unless something has been decided, you shouldn't be expected to pay for a future what if. Inspection issues. I highly recommend that you have any property inspected by a professional home inspector before buying. If there are any inspection issues, the attorney should include them along with the report or an excerpt from the report in the attorney approval letter. The attorney can request that the seller repair the items, but personally, I prefer getting a credit and fixing the items myself. Most sellers will just have the items repaired at the lowest cost possible, and that may not be what you want if you intend to hold the property for any length of time. Or the fix may not look good in your opinion, and then you will be arguing about the nuances of the repair with the seller saying it's done and the buyer saying it isn't done in accordance with their expectations. So again, in my opinion, and based on my experience, a credit is the best option for both the buyer and seller for any repair issues. Warranty of items. The attorney should put any items in writing that may have been verbally told to you during the contract negotiation, and once these are in writing, you'll have a much easier time pursuing legal action if the seller misrepresented any of these items. An example would be a seller saying they never get water in the basement, or that the air conditioner works, but the inspector couldn't test it since it was too cold outside during the time of the inspection. Liens or unpaid bills. The attorney approval letter may also state that there are not any unpaid contractors that could potentially file a lien against the property in the future for work completed but not paid for. Title insurance should also cover this, but it doesn't hurt to include it in the letter as well. The seller attorney will also send a letter and your attorney will need to explain each item in the letter sent to you, along with giving you options and an explanation on how to respond to each item in the other attorney's approval letter. The seller attorney will attempt to protect the seller from any future liability or issues after selling the property, along with trying to minimize the costs required to close the transaction, while the buyer attorney will do the opposite. If you are doing a short sale, foreclosure, seller financing, or any other unique transaction, there will be additional items in the letter to protect you in those transactions. If you are doing any sort of special transaction, it is even more important to have an attorney who is experienced in these types of transactions in your area of the country, as these can be much more complicated. Land survey. Typically, the seller's attorney will order and pay for a land survey, and the buyer's attorney will review the survey to confirm that there are not any unknown easements or encroachments, along with a confirmation of the exact property boundaries and legal description. In some transactions, like a foreclosure, auction, or short sale, the seller may not pay for the survey, so be sure to read the contract, and if the seller is not providing the survey, I highly recommend that you order one yourself and have your attorney review it for any issues. The seller's attorney customarily orders the title commitment from the title insurance company. The buyer's attorney will confirm the legal description is correct and matches the legal description on the property survey, along with reviewing any liens or defects in the title. It is extremely important that this document is fully reviewed and any issues are corrected before closing, or they will carry over to you as the new owner of the property. Title insurance will ensure that you are not responsible for any items that haven't been reported, but that may come up after closing, which is why it is critical to have title insurance. The buyer attorney will also obtain and review all zoning certificates, paid water and sewer bills, paid assessment letters, and any other releases or approvals that may be required for the property you're purchasing. If you are obtaining a loan, the contract will normally state a mortgage commitment date, and if you do not have a commitment from your lender at that time, your attorney will need to ask the seller attorney for an extension of that date. Some areas of the country will require transfer stamps, and depending on who customarily pays for them, the attorneys will need to ensure they are obtained and paid for in your transaction. In most transactions, the closing agent and title company will produce a closing statement which combines all of the credits and debits in the transaction. The buyer attorney will supply the costs that they are aware of, including the lender's mortgage information, and the seller attorney will provide their costs, and if there are agents, the agents will supply the commission statement to the closing agent or title company, who will then compile it all into one closing statement, which will be reviewed by both attorneys. Here is another area where your attorney will look out for your best interests. There are a lot of fees and line items on a typical closing statement, and since you probably don't buy or sell real estate very often, you will likely not know what each item is, let alone if it is a fair price. My attorney has struck fees that were not legitimate or fought to reduce other fees on many occasions, and honestly, I had no idea about many of the items, so I would never have questioned them if he hadn't. As your closing day approaches, your attorney should let you know how much money to wire to the title company or to bring a cashier's check. Normally, this would only pertain to the buyer, but if you are selling at a loss, you may need to bring money as a seller to pay off your loan. Be sure to never use wire instructions from an email without verifying them by calling the title company and/or your attorney. And don't reply to an email or use the phone number in the email. You must look it up separately to ensure the email isn't a phishing scam. After the seller has moved out, and normally the morning before closing, it is customary to do a final walkthrough of the property to ensure there was not any hidden damage or the seller completed required repairs or left items that were supposed to remain at the property. If you see any damage or items are missing, be sure to take a picture so you can have your attorney negotiate a credit for those items at the closing table. So far, everything I've discussed is happening before you even get to the closing. Closing day. Whether you are the buyer or seller, be sure to bring your driver's license and a checkbook to closing. At closing, there will be a stack of legal documents which require a signature by the buyer and seller. Your respective attorney should explain exactly what each document is and the contents of each one so you are aware of what your obligations or rights are after signing each document. Hopefully, the lender wires the money for the loan on time or early, and the title company will ensure that all outstanding bills are paid if they haven't already been. The title company will record the deed and issue checks to the real estate agents, pay off the seller's mortgage, if there was one, and sometimes issue checks to the surveyor and attorneys if they are not being paid directly by the buyer and seller. At the end of the closing, the buyer and seller will have a package of fully executed documents for the purchase or sale of the property. The buyer's package will include the mortgage documents and perhaps coupons to make the first few mortgage payments. As a quick side note, the keys and garage door openers or other remotes should also be transferred at this time as well. Clearly, there are a lot of complicated items that must happen before and at closing, which provide many opportunities for a deal to go sideways, which is why it is critical that you have an experienced real estate attorney in your corner for every real estate transaction. So, how should you find and select an attorney to represent you? Let's start with experience. You don't want to learn with an attorney. You want an attorney who has completed thousands of transactions and can give you solid advice based on their years of experience. So experience in the area and type of transaction you are doing should be critical in your selection and evaluation process. Next should be honesty. You can't exactly test or have 100% confidence that your attorney is honest, but each attorney should offer a free consultation where you can ask questions and get to know him or her to see if this is a person you feel you can trust and will work with well together. Verify. Look up the attorney on the Bar Association website to verify that the attorney specializes in real estate and has a current license to practice in your area. Reviews. Examine the attorney's online reviews and read through the comments as well as responses by the attorneys if there are any. References. I know references are normally given by friends or clients that do a lot of work with an attorney, but if you can get some references, I believe you can get a better feel for the kind of person you'll be working with by talking with his or her best clients. Yes, I'd prefer to talk to some disgruntled clients, but they may be a little more difficult to track down. I really hope this helps you better understand what a real estate attorney does and why you should have one representing you in all of your real estate transactions. I have included the attorney I have used for all of my personal real estate transactions over the past 20 years in the description below. And if you are doing a deal in the Chicagoland area, I would highly recommend talking to him. I have also worked with him as a real estate broker, and he has represented many of my buyer and seller clients over the years as well. If you like this video, please consider subscribing to my channel and smashing the like. I hope you found this video helpful, and if you have any other comments or stories regarding real estate attorneys, please share them below. Thank you for watching Kenton Knows, and I wish you the best of luck with all of your real estate investments.